skúsim v tejto papiere popísať fotky. Ja zatiaľ idem skontrolovať. Okay. Ja sa vám Sluchatka tak ako bolo. 0 znamená, že sluchatka počúvať slovenčinu.
Viete, kam som sa? Toto je ono, ja. Koľko slov mám dosť? A to znamená, ja nemusím hovoriť takú nejakú do YouTube, že ak by ste ma nepočuli, tak sledujte vám, to oni vedia.
Áno, prakticky. Nižšie rozprávať, aby to bolo nižšie. Ale ak budú mať problém, tak sa budú toho, aby budete tiež počuť.
A platí, že začína sa od druhej, alebo...
Áno, by sa mali postupne vykládať.
Hovoríme o filozofii, teraz som sa tuto stretol, som to s doktorom Savelom, z katedry filozofie a dejín slobody, to bolo naozaj také pre mňa najsilnejšie hodiny s ním. Raz sme mali metafyziku.
Dobrý. Pozdravím vás. Dobrý deň, Slák. Budeme asi spolu kolaborovať. Nič by tam nemalo byť asi také nečakané. Jedna pani z Talianska má problém s dieťaťom, myslí k lekári, tak bude pripojená cez mobil. Pri najväčšom ten posudok prečítam ja. A ja prečítam od slova do slova. Nie je to dlhé, takže ostatní neručí, čo povedia, viete.
Jasne.
Pochybujem, že sa budú zapájať do diskusie, to neviem. Skôr nejako áno.
Jasne, tak veľmi pekne ďakujem za ten anglický váš, to naozaj to bolo veľmi veľká pomoc, aj teda aj docentka pripravila tie prezentáciu, takže to bolo naozaj, ja som Ja mám veľmi rád právnický štúd, nie som právnik,
Ale mali si veľký úspech medzi právnikmi, takže áno, môžem vám povedať, že je to veľmi zložité. Ja si veľmi vážim túto robotu vašu, lebo viem, že je to strašne ťažké.
Je trošku iné, keď buď človek priamo tlmočí z listu, alebo ten dotyčný človek rozpráva voľne. Minule to bol naozaj pomerne text. A sa trošku ťažšie niekedy odčíta, že kam to asi smeruje. Zvlášť, že teda nevenoval rímskemu právu, ale naozaj mňa to bolo zaujímavé teda zistiť, že do akej miery už mali tie inštitúty.
Viete čo, my sme už na ne zabudli. Takže pre nás právnikov bolo to dosť zložité, nie je to ešte pre vás. Možno aj výhoda, že ste boli poznačení týmto, lebo mnohé z tých inštitútov my už úplne ináč chápem, v iných súvislostiach, v iných dimenziách. A na vlastnú škodu.
Na jazykovom ústave venujem vlastne teraz takej jednej monografii, ktorá práve zameraná na štýl, alebo teda kvantitatívnu charakteristiku rozhodnutí, ktoré sa dajú skúmať ako pomocou korpusu a štatistiky.
Rozumiem.
To, čo vlastne máme ako istú intuíciu, alebo čo jednoducho platí o tom jazyku, že človek tam nápadne viac a tak sa dá kvantifikovať. A mňa overiť, či to je naozaj ten rozdiel, povedzme to, verbenový rozhodnutie, alebo teda podežovanie na tie zaužívané ako stavebný blok. Nedá celkom kombinovať, že hoci je to zdanlivo v takom prirodzenom jazyku, presne definovať.
Je to obdivuhodné. Ja som zakladal u nás zbierku zákonov a som teraz aj členom riadiaceho výboru Slovenskej terminologickej siete, pán Štefánik, čo riadi, a každý rok máme také stretnutie. Teraz to bolo akože média, Brusel a tak, ale to rok predtým bol mimoriadne zaujímavé. Neviem, či poznáte to?
STS, no tam chodím.
Podievate. No tak potom viete, že je to tam je to veľmi, veľmi užitočné a taký bol jeden chemik, ktorý zase úplne
toto. Ďakujem. Dear colleagues, dear members of the Scientific Board of Komenského University, let me start with the presence list and ask for starting the recording session. I was asked to start with a presence list with an inaugural committee so that everything is recorded. Mr. Chairman is present. Is Professor Michael Simon present? Sure. We proceed with members of scientific committee, Professor Burda. And the members of the scientific board are asked to claim that they are present.
nemám kontakt. Profesor Zanobedy, nemám kontakt.
Jasné, ja bohužiaľ takisto nevidím, že tam sedí.
Neviete tlmočiť tak nejako, by ste to mohli?
Mohli by sme, ja som nechcel do toho vstúpiť, ale možno ten kanál je funkčný. Veľa. Nie? Let me just count the members which are present here, whether it is possible to proceed with the meeting. It will take just a while. I can state that there are 37 members of the scientific board present, of 50 altogether, which is enough because of the cutoff point is 34 members. I hereby open the session of the scientific board. So this means Professor Slashtian is present as well, which makes us 35 members of scientific board. I can state that there are 3 opponents present. Professor Alessandra Sanobetti, if you could please confirm that you are She's winking right now. Okay, we will be using this channel. All 4 members are present as well, so we are able to proceed with the inaugural lecture of Lucia Mokra. I hereby open the session. We are at the point number 1. We have to approve the program. Now only members of scientific board shall vote. The program was sent to you for approval. I also propose the traditional scrutators. Are there any remarks, proposals with regards to the program, its completion, enlargement, changes whatsoever? There are no. Let's close discussion to this point. I ask the members of the scientific board to realize a secret vote about the approval of the program. In points 1 and 2, we vote about the proposal number 1 and number 2. For the participants, we just wait until this secret vote is over, and we wait to the presentation. So until then, you can just wait. Technical issues are being solved, but we still await the result of the vote and presentation afterwards. In the meantime, some technical details about the inaugural meeting. You see that we have several guests from foreign countries, members of the committee. They have interpreting service at their disposition, the same as last time or last session. The opinions of opponents will be presented, opponents in English language, and this part, with certain delay, will be interpreted into Slovak language. This is not a case that we will not be able to understand text in English, but the procedure has to be fulfilled as it's stated. As for the discussion points in English, Lucia Mokra's answers will be repeated in Slovak as well. Again, that is because of the code of the proceedings. Okay, we believe we said everything that needs to be said. I'd like to ask the screw takers. So, as for the point number 2, roll 21 against 0. That means the point number 2. Proposal number 1, or 37 against 0, withheld 0. I confirm these results. However, the point 2 was just a preliminary results. There is still possible to vote for those entitled to do so. I believe we can conclude the vote process. Now the definitive results. As for the point number 1, for 37, 0 against, 0 withheld. Thank you. Point number 2. For 33, 31, excuse me. Means 31 was for the proposal number 2. Thank you very much. I can state that both proposals were accepted, approved, and we can proceed to the point number 2 of the program. Point 2 of the program, appointment of Associate Professor Lucia Mukra from Komenského University from Faculty of Law from the Institute of European Law in the field International Law. This is an inaugural lecture. I hereby give words to the chairman, Professor Jan Svak. Professor, the floor is yours. Thank you very much. Dear guests and dear members, let me introduce you to today's session of Scientific Board, which will concern inaugural lecture of Associate Professor Lucia Mukra. For this purpose, inaugural committee was created, whose members I hereby welcome. I was voted to be chairman. Members are Professor Alessandra Zanovetti from the University of Bologna, Professor Jania Hojnik from the University of Maribor, and Professor Michael Siman from the Pan-European University of Law. The opponents are Professor Sara Tonnolo from the University of Trieste, Professor Peter Christian Müller-Graf from the University of Heidelberg, and Professor Miroslav Slašťan from Communist University in Bratislava. As for the theme of the inaugural lecture, the following was approved: the positive obligation of the Slovak Republic to international human rights treaties in decision-making of international quasi-judicial and judicial authorities. Today's proceedings will adhere to Slovak legal regulations, which are then named. I would also like to inform about this previous session. The applicant has fulfilled the criteria which are necessary to fulfill in order to achieve the academic title of professor. The inaugural committee concludes that the criteria has been fulfilled in all respects, and quantity and quality. The committee has unequivocally accepted that the applicant fulfills the criteria which are required in order to achieve the professor title, and states that Associate Professor Lucia Mokra also fulfills all pedagogical and academic criteria. With respect to this, the inaugural committee recommends to proceed in this proceeding and to present the inaugural lecture of the applicant. I would like to thereby welcome Associate Professor Lucia Mokra, which shall present her lecture, and I ask her to do so. With the title which has already been said, the chairman of the committee has accepted this opinion of the committee, which means that today, the 30th of September 2021, the inaugural lecture can take place. After the welcome of the applicant, Lucia Mokra, I would like to present the applicant, as well as the presentation during the lecture. Associate Professor Lucia Mokra was born in Bojnice in central Slovakia. She graduated Faculty of Law as well as Faculty of Social and Economic Sciences, both at the Comenius University in Bratislava, where she gained this very needed combination of both jurist and social scientist and economical scientist. Apart from the Comenius University in Bratislava, at the Institute of European Law, that means international law, She's since 2014 the Dean of the Faculty of Law at the Komenského University. This is a very brief presentation of the biography of the applicant, but most of all the scientific presentation, which then will be added throughout the presentation. I will also ask the applicant, Lucia Mokra, to present her inaugural lecture. I would like to ask to hold the limit of 20 minutes. Associate Professor, very welcome. The floor is yours. Thank you very much, dear guests and present guests and members of the scientific board, ladies and gentlemen, and members of the committee and opponents, dear guests. Let me present my inaugural lecture, which I also created a presentation for in slides. I hope it will be visible very soon, so that everyone can follow. The theme of my lecture is the positive obligation of the Slovak Republic to international human rights treaties in decision-making of international quasi-judicial authorities. I use the actual situation and development within this area. Human rights are one of the pillars of the democracy and the rule of law, and the fulfillment of this obligation is very important, not because of new legislation approved in the respective country, but also regarding the application praxis. It is a question whether a country can fulfill its obligations and to protect the rights of its citizens. In the international area of the UN, has experienced a serious evolution in the last decade, where a system of control has been also developed a great deal. In this European area, we can see a shift in this praxis, in this decision-making. Some countries can be named, where the function of international quasi-judicial organs or bodies or authorities has been promoted ever more. The main goal of such a praxis is to effectively protect the human rights and to ensure the law enforcement of such rights in the global measure, and fulfillment of obligations with respect to international human rights treaties. International obligations or positive obligations, what it contains, it places a duty on state to take active steps in order to safeguard treaty rights. It can take different forms. It can be explicit text, or it can result implicitly from the text. It can also be formulated based on relevant judicial and quasi-judicial authorities. This means that the obligation has a very serious function. It is important to ensure the rights of every individual, including the citizens of Slovak Republic. The Slovak Republic has the duty to apply international treaties and this framework of rights, because it is member of the UN since, according to Articles 55 and 56 of the treaty, which claim to fulfill such claims and such obligations. And this is far-reaching consequences for all domains of social life. This obligation from the side of Slovak Republic is defined in the Slovak Constitution as well, which acknowledges the preference and prevalence of these treaties according to Slovak laws. It means that the Slovak Republic acknowledges that these treaties precedes over laws approved by the Slovak Council. Speaking of treaties that are in question here, that concern Slovak Republic and where the Slovak Republic has a positive obligation, you can see these treaties listed in the presentation, but there are also international treaties approved by Council of Europe, which you can also see at the presentation, which are listed on the screen. I will not read them all because of the time factor, but you can see them for yourselves. My main research aim was, which I'd like to point at, is that a different status of application praxis in application and enforceability of these international judicial bodies. Within the UN, the judicial bodies, there are judicial bodies, or general courts, or quasi-judicial bodies, which are committees of the UN. These deal with the human rights agenda and govern this area. They are a monitoring body, but by certain ratifications, effective from 2014, these bodies of UN were given a quasi-judicial character, a quasi-judicial nature, which are the topic of my research aim. And I would like to present these in this presentation. As for the Council of Europe, we have a judicial authority which is stable, and that is European Court for Human Rights. I can also add, can we consider the European Chart for such a treaty? So we can place the question whether the Charter is an international treaty or a legal act of the UN, which was denied then. As for the courts and quasi-judicial bodies, these decide on applications regarding individual, on violations that are guaranteed by international treaties, which is a common practice, which is a common experience in our praxis with regards to human rights. And we have the decisions of quasi-judicial bodies. These bodies are essentially judicial in character, but not within the judicial power of infrastructure. They have a partly judicial character. They have even jurisdiction, they have rights to whether there has been a violation of human rights. They have also jurisdiction when it comes to monitoring of following the human rights. We can take an example of the European Court on Human Rights. This will be a topic for the presentation for today. This court is a stable body. Its decisions are not self-executing, so the execution or fulfillment of its decision is guaranteed by the member state, while as the Committee of Ministers of Council of Europe supervises the execution of these judgments. The final judgment, which can be explicit and implicit, is supervised by this committee. I can name several cases where court explicitly stated that violation of human rights from the side of Slovakia, especially, or for example, the case Lexa versus Slovakia, where the court stated that the Slovak Republic did not protect Mr. Kovač Jr.'s fundamental rights, which means that Slovak Republic violated the convention. Similarly, in the case Kontrova versus Slovakia, the court has concluded that the police did not fulfill its obligations. So, despite the repeating situation, the state authorities, like police, the Slovak Republic was not able to ensure that human rights and all provisions of the regulations were upheld and fulfilled. And the court has stated that Slovakia has not only did not fulfill its obligations, but also violated its positive obligation. Despite that Slovakia has pledged itself to follow these human rights. The judgment also means that the violation of positive obligation means also is a per se violation of human rights. In case of these decisions of the European Court, these decisions are enforceable, relatively strictly speaking. According to paragraph 193 of the Slovak Civil Litigation Code or Civil Contentious Code, you can see this paragraph on the screen, which means that unequivocally there has been violation of human rights. Another example was the decisions of quasi-judicial bodies, such as UN committees. Firstly, the monitoring committee is such a quasi-judicial bodies. There was created a mechanism of individual submission, which means that outcome of communication is the opinion or decision or statement or recommendation of the committee from these quasi-judicial bodies. These opinion consists of several parts. First is the fulfillment of the obligations by relevant state party. The second part is the reflection, which is partially reflected in Universal Periodical Review. And there are also recommendations for legislation amendments as defined in this statement. We can state several examples of these proceedings as well. I can point at statement number 56, which concluded or stated that the Slovak Republic violated positive obligation in relation to implementation of anti-discrimination law and requirement of accessibility of judicial proceedings of victims of racial discrimination. Similarly, there was a case in Committee Against Torture. In his final statement or final recommendation, there was stated that there was positive obligations violations due to non-fulfillment of principle of independent investigators guarantee and protection impartiality. In the first decision from 2014, there was no such decision because the question is now the enforceability. In the system of national law, it is quite hard and difficult to receive the justice which was acknowledged by the court or the international bodies. So now just to summarize this very briefly, as for the differences between judicial and quasi-judicial decisions, judgment of European Court of the Human Rights is enforceable on national level, while as the UN committees states or edits decisions and positions and recommendations, which in the case of European Court of Human Rights, it is also possible to receive a financial compensation. On the other hand, as for the UN committee, there are no such regulations with regards to positive obligations, and there are no place for real enforcement of such positive obligations should such a violation arise, which means what should one do in such a case, and how can we contribute to fulfillment of such a positive obligation? We can be inspired by the decisions of or decision making of Supreme Courts. These can be ensured firstly when amendment of the Constitution and following regulations. But also this could be achieved by some more fundamental changes. As for this legal regulation, one can achieve a harmonization of legal terminology, so that the content of application would supersede or precede over national laws, and enlargement of the amendment of the relevant provision of the Civil Litigation Code. I hold it that if we recognize the supremacy of international human rights treaties, it is also necessary in place for the effective protection of human rights to recognize the decision of international bodies as well, even though they are not self-standing bodies. These results of my research, as well as other aspects of the human rights protection, I try to bring into reality, as well as to be active in three mainly areas. These are these following three. The first one is contribution to the legislation. I was active during the National Strategy on Protection and Promotion of Human Rights, and I'm a current member of advisory body of the MFE for Agenda of Social Transformation. These are my activities in the first point. I prepare recommendations for the UNESCO concerning the human rights protection in the area of AI technologies and the protection of human integrity in this area. We prepare research materials so that European Parliament can conclude with or can state their statements. I'm also active as a representative in Intergovernmental Council in UNESCO. In UNESCO, I'm an expert for European Parliament. And lastly but not least, these are my contributions to research and education in the following points, which you can see on the screen. It is preparation of curricula, supervision of PhD students, actively in the current contemporary topics of human rights. And I'm also partaking in international research projects, lastly in Horizon 2020, dealing with differentiated integration, which means amendment the national legislation. Sorry. Given the time I was given, I would like to thank you for your attention, and I'm open for any further questions. Thank you very much. Thank you very much as well, and thank you for the presentation, which concerned not only the team itself, but the contribution for development in this area and development in the research in this area, because human rights protection can be seen as a science. This is a definitely relevant issue which has a certain place in. I hereby open the public discussion. Every present guest can attend this discussion. I open it right now, and if you have some question, please go ahead. Professor Vacok, thank you very much. I use the opportunity. Dear Lucia Mokra, you spoke about the right of precedence with respect to judicial bodies. Isn't it a quite bit of dangerous if courts should respect international treaty bodies that have different status? And the second question is, what should be regarded as a quasi-judicial body in order that the situation remains controlled and not became chaos? What should be defined, and who should be respected as a representative of a quasi-judicial body? Is there a clear definition of such a body? Thank you very much. I propose that we should first hear 3 questions and first then give place to give room to answers. Professor Müller-Grab, the floor is yours.
Otázka ešte o Komenského.
Very much for the question. We can now give, if there are no more questions, we have a question still. Thank you very much, Mr. Chairman. I have a question regarding, in connection to a recent judgment of the European Court of Human Rights in the case Carter, which concerns the Litvinenko's case of criminal case. To what extent should Slovak Republic, in this context, and in which intensity shall be held responsible for such a violation? Is there a difference between fulfillment of such an obligation within a country or in this extra territorial context? Thank you very much for this interesting question, which has a wide scope and concerns not only Litvinenko, but several more cases and a wide area of humanitarian rights in other territories. But I'd like to not become too wide. So I would like to ask applicant to answer questions. Thank you very much for the questions. I will follow the order. So, to the first question. I would say that international law is characteristic by that it decides its content, not the form. We can point to an example here. Important is what is the content of the application, not its form. And the international form creates such a place, a platform for dealing with these issues. So I can only repeat the focus is mainly on the content of the application itself, not the form and the formal aspects or formal features of these applications. If there is such a recommendation in the judgment, there is also an appeal to create a mechanism which would enable the state to fulfill its requirements in order to restore the original state of art or to give compensation. And to the second question, how to prevent the dangers of such a high status of quasi-judicial bodies. These are stated in the protocol and respective protocol and regulated by European law and by UN law, adopted by relevant laws. Which I already mentioned during the presentation, so that there are these regulations, treaties explicitly stated, given by the protocol. So, but I think the national regulation with this respect would be able to, in cooperation with national courts, and to ensure that in these cases, as in Finland, Spain, or Norway, to set a certain common standard so that there would be a unified procedure in these cases and in these circumstances. So it would be clear whether to address the Committee of UN or other organs, which would then ensure the restoring of justice. This is also bound to certain formal procedures. So the individual has to decide which body he or she should address. And it should not matter what kind of body I address or I apply for. It would be this should be a unified procedure for all these bodies. Thank you very much. The second question. This is just a rephrase of the question. This is a very important question, an interesting question. Slovak Republic has, due to Lisbon Treaty, does not concern the chart of human rights. But as an example, I can point to the case of Czech Republic, which dealt with this question. and deal with the question whether the chart is such a treaty and compliance with the EU law shall be examined or not, and is not taken as international treaty. The Czech Constitutional Court was very explicit in this respect and stated that he considers it to be a legal act of EU which was certainly politically explained, but was also politically motivated. But the decision could also look otherwise. And because our judicial system is very similar to the Czech one, the discussion is absent in this respect, or with respect to this issue. So we do not experience such a discussion about issues like this, but I do not exclude a situation where it would be like this, which would mean that we would be required to deal with this question as a state. This would also mean that it would be incorporated in other treaties which the Slovak Republic is bound by. And as for the last question, to what extent the Slovak Republic is or should be or could be responsible for territorial fulfillment of human rights, I could claim the one basic thing: the positive obligation is formulated as a very strict or formal anchored obligation in international treaty. But human rights, apart from being formulated as obligations, they are also a value which represents a certain frame for behaving and treatment of a given state, and how to implement regulation into the praxis. So if the state should extraterritorially fulfill such an obligation, we cannot legally argument for such an obligation. But my point is, the country should have a positive obligation regarding also extra territorial claims, because these issues represent basic elementary democratic values, which are valid throughout the European continent and concern all. Thank you very much for this first series of questions, and I can again open a new round of questions if there are some. Mr. Professor Fabri, thank you very much for an interesting presentation. There were plenty of interesting topics were opened. As for the comparison between the states, democratic states, I would be very cautious when it comes to definition of what constitutes a democracy or democratic state. If we look at, for example, certain statistics regarding the number of applications and complaints addressed to the European Court, and as for the quality of these applications, it does not the situation is not like this, that the countries that claim to be democratic have applications and complaints on such high level, meaning democratic level. And Slovakia seems to do quite well in this respect in comparison to other countries. And I also like to comment on one topic: to which extent we, through decision making of European Court of Human Rights, we can experience an there could be a violation of jurisprudence in regards to national and constitutional law from outside, so to say. Because these decisions have a serious impact into national economics and even economics. So the question was raised: to what extent this question can be even decided by European Court of Human Rights, and whether this is not a case of violation of jurisdiction from the side of the European Court. And we can point to a Russian example from recent time, where there was, which concerned a great deal of money and a very large impact into national judicial system of Russian Republic, Russian Federation. The next one will be Professor Michael Simon. Thank you very much for the lecture. I would like to ask, in connection to decisions of European Court, that they are enforceable, which was stated as one of the defining features. Have you been concerned with proposals for making these procedures better, to improvement? How to achieve the best way of solution of dealing with procedures in such complicated cases? I know that Slovak Republic, there are cases that, despite the recommendations from the European Court for Human Rights, the Slovak Republic did not adhere to these recommendations. So, for example, there was no renewal of a court of a legal procedure in a given case. But this is a problem in other countries as well. It does not only concern Slovakia. So, if there were some efforts to improve this procedure, could you characterize them? That was the question number 2. Are there any more questions? I do not see any more questions, so now's the time for answers. Thank you for the second round of questions and commentaries. As for the first question, which is now rephrased, the convention itself claims that the court decides, and if there will be if there was a violation, into the elementary human rights. So next phase is eventually compensation or other kind of making the things right. If the violation is very serious and severe, which is not possible to compensate, the court decides to place to fine the state with a very severe financial sanction. But this is a trend, this is a tendency or instrument. This is a sanctional mechanism that can be used. It can be used if there is no other remedy possible available. So the last resort would be a very high fee, or so to say, financial sanction, which would compensate for the violation. In the case like with the Russian Federation, the Russian Federation had the possibility to choose another remedy, which was not the case, which was not being realized. So when it comes to the question whether this is an instrument, a political instrument, the court itself decides on basis of values, certain values and treaties. So it should not serve as an instrument for political sanctions against concrete countries. And this is supervised by the Committee of European Ministries. I cannot calculate the exact amount or the exact rate of compensation, so I cannot deem whether it was appropriate. But in my estimation, was this fee or the sanction was appropriate given the HDP of the Russian Federation, GDP of the Russian Federation. There's also a question of how many citizens in all address or raise application, file a complaint against a given state. So we need to look not at the absolute numbers of applicants. We need to look at the percentage. So the rate of citizens which restore to this possibility and file a complaint. So we should be very cautious when dealing with quantitative characteristics of or statistics of such overviews and tables, and do not absolutize And as for the Mr. Simon's question and the question of enforceability against Slovak Republic, the decision of European Court in itself is enough argument for renewal of a legal procedure of a case. This is not a systemic change that needs to be done, but a change that is rather to be done with respect to education, lifelong education. I would like to accentuate the quality of education also in the university settings and with regards to next generation of lawyers, which should improve the quality of judicial thinking in the future lawyers and people that are dealing with human rights in this area. I do not see any further question, but there is also a reaction by Docent Fabri. I do not wish to prolong it too much, so I will be brief. In this respect to the 2 billion fine given to the Russian Federation, we can place them in context. The adequacy of such a high financial sanction, it can be set into the context given by some legal principles. The allegations from politicization of this case come from both sides, from both parties. As for the statistics, I would like to point out to the fact that the annual report statistics, these seem not to confirm these results do not seem to confirm the chart of democracies or chart of democratic countries, which we deem democratic in our opinion in the general public. Thank you very much. And now reply from the applicant. Please use the microphone. Just a very short reply. One can be seen open scissors in the decision making when it comes to some of financial sanctions. I would like to point at the case Kontrova versus Slovakia, where the court has concluded that enough satisfaction would be from 10 to 40,000 euros. In similar case in Great Britain, this similar case was given a 40,000 euros fee. So this could be interpreted as the life in Slovakia is worth 10,000 euros and the life of a person is worth 40,000 euros in Great Britain. This would mean that life is not worth the same in all countries. Thank you for all the replies. One more question from Professor Nemec. I hesitated whether to partake in the discussion, but I tried nevertheless. I was inspired by one book that I read recently. I do not Beyond the Horizon of Human Rights by a French philosopher. It's a big critique of European human rights concept. I was very surprised. But according to the book, in France, we have a very living discussion with respect to this issue. With respect to the concept of subjectivism and universalism. Whereas subjectivism claims to be valid at a certain area or a given culture, the universalistic claims the universal appeal of rights wherever they have been applied or they should be applied. As for the question which we will return to, I know about the book, but I know about this approach characterized by subjectivism versus universalism. I would like to accentuate that you need to weigh the approaches and various aspects or moments in each and every case. So the procedure should be continuous. We shall always counterweight or found a counterbalance between various aspects in each case. In our Central European region, this discussion is evolved more into whether to be active or too active with respect to the human rights protection. We can name an example given to the coronavirus pandemic situation, which raises the question to what extent should the Slovakia or the country should fulfill its positive obligation, should be active and impact the life and movement of its citizens. Because the instruments that the state has limited resources and tools, so the state in the last instance must decide each and every time to which direction the state should be heading. Should it be even more strict or more active? Should it invest more into perhaps some other areas? So the position of the state is quite demanding. I can name an experience from Prague, a recent experience, discussion with lawyers there. We can state that Slovak Republic has experienced a serious, substantive development in the human rights protection, which is a pleasant news, which is a good news. So I would accentuate not to pick up those cases where the Slovakia violated human rights, and those do not omit the cases where Slovakia was freed because there was no such violation. It is important to point at positive examples, and there are plenty of such positive examples, but from whatever reason, only those negative are accentuated. The division between politics and philosophy is very thin. I see that constitutional lawyer Mr. Shikota will pose a question as well. Thank you very much and good afternoon to all. I would like to, with regards to second answer, I would like to support the applicant. I can assure you that the European Court has a very detailed methodical procedure in order to come to the conclusion what kind of fee should be placed on the violator. In this methodical procedure, several aspects are recognized and taken into consideration. So the European Court is aware of the situation, different situation in various countries, economical situations. Thank you for this rather confidential information that European Court has this insight. Thank you very much. I see no further questions. So this means I would proceed for the next point, which would be the opponents. To present the substantial, the most important part of the opinions from the opponents, where the opponents should present several sentences from the opinion or from the review. So as first will be Professor Sarah Tomo with her assessment, reviewer's assessment. Yes. Je to,
Nemôže predniesť.
you can now present.
Teraz to asi možno použiť.
Thank you very much for Professor Graf. It is my great pleasure to be a member in this committee, and as a person who perhaps on a daily basis, on a personal level, in contact with the applicant, I feel the urge to claim or state that her pedagogical activity since the very studies, or several studies, successful studies, I know about them, and I'm aware that immediately after the first studies, she engaged in pedagogical activities on various levels, in various forms. I accentuate that the pedagogical activity is in fact her substantial professional activity, which is rather rarity, or quite rare in these circumstances. Her activity is constant, and it's even still more productive and still better. Her exclusive orientation towards consists of constitutional right, constitutional law, and other branches of law in Slovakia and in other areas. It is understandable that pedagogical activity of the applicant has, according to my knowledge, a high, very positive feedback among students in all classes. Her seminars and courses are very demanded. I believe that the applicant represents a stable member of the team. Based on the publicational activity, I find it important to point at these publications that were published in respectable foreign items, publicational items, published in respected current media. She promoted 5 PhD students, and in the meantime 9 more PhD students, which means she's fully engaged in the process of bringing up a new generation of lawyers. As for the grant projects and funding projects, where there are some requirements, I can state that based on the materials I have to my disposal, that she's engaged in 38 accomplished and 7 ongoing projects. This criterion I find fulfilled very simply. Similarly, I'd like to state that the applicant in general mostly publishes mainly abroad in English language, that is. This ensures her a very great deal of attention from foreign scholars. There are more than 104 publicational items in all categories, and I'd like to also stress her endurance when it comes to teamwork, because a major deal of these publications was created in collaboration with colleagues from the praxis and from the field. I myself was engaged in was active during the preparation of several of her publications. I especially like to point at her applicant's ability to hear others' opinions, to evaluate it, which I take as an absolute credit for her, which is almost unique in our milieu. Concludingly, there is undeniable fact that the applicant is mainly concerned with European law with connection to constitutional law and human rights orientation. This orientation is no coincidence, this is not partial, it is simply a culmination of several years of continuous and very throughout activity in this field, in this domain. I also positively value her effort to improve the EU law when it comes to handbooks, teaching materials, as well as with regards to human rights protection and other law branches. Also in comparative dimension. I take my liberty to conclude with, based on all facts that I presented here, that I recommend to appoint Professor Lucia Mokra as professor in the field international law. Thank you very much. Thank you very much as well. At the same time, I would like to ask the applicant to eventually, if there were certain questions involved in the opinions, to express her stance towards the peer reviews. Thank you for giving me the floor, and thank you for the opinions from opponents. This is something I appreciate very much. Also the fact that they moved through my whole career, where I moved from the national level to the European level. There are no substantial remarks or questions. I only wish to declare further that my work does not end here. And scientific research I wish to develop even further, because this is a mission of an academic. As we have heard in this discussion, it is not about the perfect legal regulations, but it is also important to raise another generation of new and qualitatively possessing a new generation lawyers possessing a quality that is required, which would enable more effective protection of human rights. I do not want about whether we have time to
náhodou to chceli preložiť, ale Už to asi nemali chcieť preložiť. Toto už je normálne diskusia. A v pohode ja vás potom prepojím do toho ďalšieho súkromného kanálu. Vy si kľudne môžete teraz asi odbehnúť. Chcete?
Nemusím, ale teraz robím čo? Teraz tlmočím ďalej.
Počkajte.
Počkaj.
Sekundu. Kde samozrejme treba.
Dobre, to už sa pomaličky možno zameriť. Dobre, takže tlmočím. I see that everyone is connected. I see that both members are present. If you allow me to, we can proceed to point number 6. I ask Professor Svak as a chairman to make us acquainted with the results of the committee. Thank you very much, dear Chairman of the Scientific Board. I would like to read the main facts from the protocol that was written down in the meantime, which I would like to follow briefly, would like to present to you. The voting was attended by 7 members. The number of present people was 7. The number of positive votes was 7. Number of negative votes was 0. Number of invalid votes 0. Conclusion: the inaugural committee decided to apply for the scientific council at the Faculty of Law with a recommendation of approval of appointment Lucia Mokra as professor in the field of international law. Thank you very much, Mr. Professor. These are good news which I'd like to hear. I can state that in all the proceedings, all requirements were upheld, were followed and fulfilled, as well as all procedures regarding to internal regulations at the Communist University were followed. So the scientific board can proceed to the final vote, which would be about the applicant. I hereby ask the members of the scientific board to promote this proposal. I firmly believe that this was a very nice inaugural lecture. Are there any more eventual questions? If there are not, I would just like to ask you proceed to the vote about the point number 5 within the program. Now give word to Professor Bertko. I would also like to support this proposal because in the recent times, applicant was being active at our institute and she was a very popular pedagogue and contributed to the scientific development by attending several projects and activities at the Institute of European Law. So in the recent years, she would become a fully engaged, fully fledged member of the team. Thank you very much for this remark. Mr. Vice Dean, are there any more persons who would like to make a statement or comment on something? If not, then we will proceed to the final vote. We vote about the proposal number 5 within program point number 6. That concerns the members of the scientific board. I would like us to scrutize about the preliminary results. Up to this point, there were 38 votes, members of the scientific board. I ask if there are some others but did not do so due to technical problems or issues. If there are some technical issues, do not be ashamed to speak out, but I do not see any remarks. I end the voting process in this point, and I ask the scrutators about the final results in this voting process. As for the actual issue, which is now voted, for, 1 against, 1 abstained. So the approval this approval was done. Congratulations to you. I'm also looking forward to next meeting, and I would also like to open the vote 7 if there are any more remarks. And I take the liberty of ending today's session of the Scientific Board. I thank you very much for attendance. Thank you very much, and I give floor to the applicant. Thank you very much, Mr. Dean, dear professors and members of inaugural committee, and opponents, and all present guests. I would like to thank to all peoples that support me on this journey, be it scientific from the personal way. Thank you for all your impulses and support, because this keeps me pushing forward. It is very important to not stagnate. It is important to move forward, and that is including the society and judicial system. No.
To mal byť bravo, nie?